Hello students, Dr. Vaishali here. Today we are going to learn the very first topic in our legal education, and the topic is meaning and definition of law. If you take any law book, there are so many definitions of law available, and students wonder why there are so many definitions of law. Do you know why there are so many definitions? Because there are so many approaches towards looking at law. For some jurists, it's just custom. For some, it's nothing but morality or a sense of good and bad. For some, it is a command of a ruler. There is a ruler. If there is a ruler in your country, his command is law. For some, it is a law explicitly made by the legislative branch of your government. For some, it is just pure a judicial decision, or which is called judge-made law. So there are these many approaches towards looking at law, and that's why there are so many definitions of law. I will try to explain these various approaches by giving you an example. This example is given by Professor Morris. He gives an example of horse. So a horse is standing there, and if a zoologist comes, for him it's a genus mammalian quadruped. For a traveler, it's just a means of transportation. For average man, it's a sport of rich. For certain nation, it's an object of food. For a soldier, it's a ride in war. So see, same horse is there, but approaches are different. Similarly, approaches towards looking at law, they are different, and that's why there are so many definitions of law. But there is pretty much common definition of law, which is law is there to maintain peace and order in society, and it keeps changing as per the changing social needs. Now let us try to understand nature of law. If there is a question in your question paper on nature, scope and definition of law, you have to start with introduction of law, like what law is and what are the different approaches of looking at it. Then you have to give lots of definitions given by the jurists. You can provide some examples from your legal system to support these definitions, and then you have to explain the nature of law. Nature of law. Before understanding the nature of law, you have to understand that law is a social science. There are two types of sciences: social science and natural science. Physics, chemistry, biology, these are natural sciences. And law, political science, sociology, economics, anthropology, these are social sciences. Basically, social sciences deal with the society. And society is never static. Society keeps changing, and so as the social sciences. And law, being a social science, keep changing along with the changing society. Journey of law is aligned to a journey of human being. Earlier human being who was living in jungle or who was living in dens, he was fascinated by the natural wonders, and he thought that law is nothing but something made by nature or by God for himself. Slowly human being developed, and so as well the law developed. So journey of law is aligned to journey of human being. So you have to understand that first. And then society came into picture, and along with the development of society, again law started developing more and more. So natural law was there, which went under evolution, and today you have your law. So this is the process of evolution, and during this process of evolution, different approaches were there. These approaches went changing, and so as the definitions went changing, and that's why we have so many definitions of law. So let us discuss these definitions one by one. First definition by Justinian. According to him, law is the king of all mortal and immortal affairs. It's a standard of just and unjust, which explains what to do and what not to do. So according to him, law gives you a power or reason to understand what is good for you and what is not good for you. Then there came Ulapian. According to him, it's an art or science of what is equitable and what is good. So initial definitions of law, they tried to explain law as divine law or as a moral law or as a customary law. Third definition is by Cicero. According to him, it's the highest reason implanted in the nature, and nature gives that reason to human being, and by using that reason, human being is supposed to make law for him or to decide between good and bad. Next definition is given by Demosthenes. According to him, every law is a gift of God and a decision of sages. So it is a gift given by God to human being. Then there is a definition given by Professor Hegel. According to this definition, law is an abstract definition of general will of the people. Then there is the next definition given by Dr. Henry Maine, and the definition is law has two notions, notion of order and notion of force. So law has to maintain order in the society, and how law will do that? By using force. Next definition of law is given by Lord Moulton. According to him, law is nothing but crystallized common sense of the community. So see, law is moving from that divine element to the common sense of a society. Now the next definition is given by Roscoe Pound, and according to him, law as a social institution, it needs to satisfy social bonds. So law is nothing but a social institution which is made to satisfy common social bonds. Then there is a definition given by Duguid, which means law is essentially and exclusively a social fact. It came from the society, it is made for the society, and it respects social facts. So this is the definition given by Professor Duguid. Next definition comes from Eyring. According to him, law is nothing but a means of social control. In society, law is there to keep some control on social activities. Next definition comes from Austin. According to Austin, law is nothing but a command of a sovereign or a ruler. It imposes a duty on individuals to obey, and it is backed by sanction. Shortly, law is made by a ruler or a leader of a country. It imposes a duty on people to obey it, and if people do not obey it, there is a sanction or threat of punishment behind the law. So this is the definition of law given by Austin. Definition of Austin is criticized widely. Okay, so while writing your answer sheet, you can provide a definition and then you can criticize the definition to increase the content if needed. So definition of Austin is criticized widely. According to some jurists, law came not with the ruler or with the sovereign. It existed in the society long before the sovereign. According to some jurists, definition of Austin is not applicable to international law because international law is not made by any ruler. It's a pact between the countries. So these are the criticisms to the Austin's definition of law. Next definition comes from the Salmon. Law is a body of principles recognized and applied by states in the administration of justice. So according to Salmon, who was again a positivist, law is made by a ruler and the purpose behind making law is administration of justice. Now let's move ahead to the next point in our answer, and that is purpose and functions of law. Just like the definitions of law, purpose of law also varies as per the different jurists or authors. For one school, purpose of law is to maintain law and order in society or just to maintain peace in society. For another school, it is social welfare. The purpose of law goes beyond the peace and order thing and it is there for the welfare of society. And do you know why this purpose or these approaches towards looking at the functions of law changed? Again, it is aligned to the journey of a human being. Earlier human being, he needed security because there was like lots of rivalries and tooth for tooth and an eye for an eye approach, and that's why that person needed some security. And that's why earlier concept of law was kind of, law is there to do a police function, because the state was called police state. Why law is there in a state? To maintain peace and order. What's the function of police? To maintain peace and order in society. So if law is performing the function of police, it's a police state. Then during the development of human being, that approach underwent a change. It became a laissez-faire state. It means unlimited freedom is given to the individuals and law will just maintain status quo. That freedom will be protected from law, and that was the laissez-faire state. And then the modern state or welfare state. Because peace and order was established, the initial police needs, they were satisfied, and that's why state moved from police state to laissez-faire state and then ultimately to welfare state. In welfare state, again functions of law changed, providing sanitation, providing electricity, providing good roads, providing good schools. In short, providing for the all-round well-being of a human being became the function of law. And that's why purpose and functions of law shows lots of variations from the early jurists to the current jurists. So let's discuss various purposes of law from the viewpoint of various jurists. According to Hobbes, function or purpose of law in society is to maintain peace. According to Austin, purpose of law is control. Controlling those human desires or controlling human being in a society from committing crime is the purpose of law. According to Bentham, why law is there? To keep maximum number of people happy. So according to Bentham, purpose of law in society is maximum happiness of maximum numbers. According to Holland, law is something more than police, and its ultimate objective is all-round welfare of the society. According to Roscoe Pound, law has 4 purposes in society. Number 1, to maintain law and order in society. So to protect people and maintain peace is the first function of law. Second purpose of law is to maintain status quo in the society. So if there is no problem in the society, law will just maintain the status quo. Third function of law according to Roscoe Pound is enable individuals to have maximum freedoms. So law will maintain a situation in which individual can enjoy maximum freedom. And fourth purpose of law is maximum satisfaction of needs of the people. So law will provide for the needs of people. Then there is a Hindu view on purposes of law, and according to Hindu view, welfare of people in this world is the function of law, and after that function, salvation or mukti is the ultimate purpose of law. According to Muslim law, discipline of soul and improvement of morals is the function of law. So disciplining in your soul and then improving your morals is the function of law. So now you know everything: nature of law, definitions of law, then advantages and disadvantages of law, and the functions of law. So if there is a question on nature of law, you are going to provide all these points. Don't directly jump to the nature of law. You have to explain everything one by one. First, you will explain what law is in introduction. Then you will cover different definitions given by different jurists. Afterwards, you will explain nature of the law. You will try to connect nature of law with the journey of human being. Change in that journey and change in the nature of law. You have to relate these things and then you have to provide. You can provide some examples from Indian scenario. Afterwards, You have to provide different functions of law and how they underwent changes, and different juries on purpose or functions of law. Afterwards, you have to discuss advantages of law and disadvantages of law, and then you have to conclude. So this will be the general outline of your answer sheet. Try to follow it, and all the best.